Okay. Good morning, everyone. So my name's Jenny Nepern. I'm the Housing Initiative Attorney at the DC Bar Pro Bono Center, and so I'm going to take you through the first 15 minutes of training. I think because we're a small enough group and we're going to be doing an interactive exercise at the end, can we really quickly just go around, say name what firm you're from, and then do you mind also saying what group you're with, if it's litigation or if you do transactional work, that kind of thing? So I'm going to start with you. We'll just go around each table. Great.
Andrea Kalem, Hunt and Andrews, Perth, Labor and Employment.
Devin Palmer, Olivia Myers.
Great. Go to you.
I'm Claire Bryan from Huntington Burnham, and I'm the driving license. Maddie Busette, also from Hunt Andrews, Perth, Labor.
Great. We'll go back to you.
John Hines, Blank Rome, Insurance Recovery.
Sean Maria, Logan Levels, I'm in the ACO for Motor Group.
And David Paul Hastings, I'm in the professional.
Great.
Diane Auerbach, Daily Piper, I'm in the real estate group. We do commercial. I don't do this, so I don't know what
That's why you're here. Okay, great. I see two more folks in the back. Do you mind just saying your name, what firm you're from, and what group you're with? Great, great. Okay, great. All right, thanks everyone. So thank you for coming this morning. I think this is a really important advanced training because most, if not all, of the housing right to counsel cases end in settlement. So it's really important that we are going into these negotiations strong and we're sort of understanding what strong protective terms. So I'm gonna jump in and start off with just sort of some general tips of settlement. So my first tip, especially for pro bono attorneys who are not often in landlord-tenant court, is to beware of settling too early. Oftentimes, when you go to that initial or further initial hearing, the landlord's attorney may say, "Ooh, I got someone who's not too experienced at this. Will you sign this, consent judgment or a settlement?" And it is, I would say, rare that you're going to get your best agreement at that initial or further initial hearing. So just beware of not settling too early. With that said, I think it's a great idea to speak with your client about what a good settlement would look like for them sort of from the beginning of the case, because more likely than not, the case is going to end in settlement. And so it's good for you to know from the get-go what kind of maybe repayment plan could your client afford, that kind of thing. So you do want to be having those discussions with your client really early on in the case. As you're preparing for settlement, there are draft settlement agreements on probono.net, but in addition to that, your mentor is going to have settlement agreements, and so definitely go to your mentor to ask for draft agreements so that you can be thinking about what terms you're going to want to include before you go into a mediation. And I think it's a great idea also to get those early on because settlement negotiations may come up earlier, right? Sometimes like opposing counsels have vacations and they just want to settle right before then, and that may be a really great pressure point where you have a lot of leverage. So it's good to already have an idea of what settlement terms would be great for your client. Before you go to mediation, my recommendation is to go sort of with a draft agreement or at least a document that has like bullet pointed the terms that you want to be sure to include in your agreement. As we'll discuss a little bit later, it's common to actually come out of mediation with a signed and then you will file that version of a settlement agreement. So going in with a draft is going to be helpful, to you. So leverage points. I just got a call yesterday from an attorney who's working on a housing right to counsel case who said, I just got a call from opposing counsel. They're in the midst of discovery and opposing counsel did not respond in the 30 days that he was supposed to. So the attorney sent the 10-day letter and alas, opposing counsel was like, I'm on vacation, I really don't want to respond to discovery. Could we discuss settlement now? So they called me up and they were like, should I discuss? I'm like, absolutely. So, when discovery responses are due, basically when there's any work that the other side would have to do, I think that's often a good leverage point to be talking about potential settlement. Also, especially before pretrial conference or any of the dates leading up to pretrial conference, like having to submit a pretrial statement, there's a lot of work involved in that. So that's another, I think, great time to discuss settlement. And then after the pretrial conference, often settlements happen, not often, but they certainly do happen at like 2 a.m. before a jury trial. So I would say it is rarely too late to be talking about settlement. So just any time that the other side, I really think of it like that, has to do work, or any time there's a high risk involved on the other side, like if there's a dispositive motion that's going to be heard, then that may be a great time to discuss settlement when you really have a lot of leverage. So preparing for mediation. I always tell folks I think it is well worth putting in the time to prepare for mediation, because I think that investment in time is going to increase the likelihood that you'll be able to settle and then not actually have to prepare for trial. So when I go into mediation, I will have with me the photos of the housing code violations. I'll have almost everything that I might want to ultimately have for trial. I want to have a really good understanding of the strengths and weaknesses of my case. Right? So mediation is usually set for after discovery responses are due. If you have to extend the discovery deadline, then you're probably going to want to be extending the mediation as well, because you want to have all of the information that you're going to ultimately have before you go into mediation. So, I really think it is well worth the time to prepare. 30 days before mediation, you're required to submit a confidential settlement statement where you write out sort of your side of the case and what terms your client might be willing to settle on. Those are often due before you get discovery responses, so they may not be exactly identical to the position that you'll have on the day of mediation, but I think it's a great opportunity to sit down, think, with your client and really think through what they would be looking for in a settlement agreement. So what to expect at mediation. Different mediators may have varying styles, but generally speaking, just so you know, mediation in jury trial cases are not at the landlord-tenant court, so it's in like a much calmer environment. It's in a building right across the way from landlord-tenant court. So the mediator will start off by asking the two sides to present their side of the story. And so they're usually going to start with the plaintiff. So the landlord or the landlord's attorney is going to explain their position, and then they're going to turn to you, and you'll explain your position. And then usually they'll split the parties up into 2 different rooms, and the mediator will bounce back and forth between the 2 different rooms to help negotiate a settlement agreement. Mediators really love to try to get the parties themselves talking, so they love to try to get the tenant talking and the landlord talking, and that's something that you should talk to your client about before you go into mediation, to make sure that you're on the same page about whether you're going to do the talking on your client's behalf, which is usually, I think, a preferred way to do it. You want to talk about the risks if the client were to speak, but you just want to have that discussion before you go into mediation. And you want to just make sure that your client is generally prepared for mediation. You guys at this point are probably going to have a pretty good sense of what the relationship is like between the landlord and the tenant. But you just want to, I think it's often helpful to try to have a calmer setting. And I think mediators, if they don't immediately separate the parties and you think that's how you're more likely to get to settlement, then you can certainly suggest to the mediator that you think it might be a more fruitful mediation if the 2 sides are separated into 2 different rooms, or vice versa. Maybe you have 2 parties that can really work well together and you want to keep them in the same room because you think that's how you're most likely to get there. So I'm just going to review some key concepts, and these are concepts that you guys probably already know, so I actually may just call on you guys to tell me what they are. So redeemable judgments. Who knows what a redeemable judgment is? Anyone? Yes. Exactly. That's exactly right. So a redeemable judgment is the type of judgment that's going to be issued in a non-payment of rent case, and the tenants can pay to stay, right? So even though a judgment will be issued that's going to be part of their public record, there's going to be an amount on that judgment called the translux amount, and that's the amount that they can pay to stay in their unit. And it's going to be that amount plus any new rent that has become due. So they basically have to get their balance down to zero. Redeemable judgments are also appropriate in lease violation cases that are for something that's worth an amount of money. So to fix something that's broken or for paying utilities, that kind of thing. Non-redeemable judgments. Who wants to tell me what that is? Anyone? Yes. Yes, exactly. It is the opposite of a redeemable judgment. There's nothing you can do to avoid eviction. Once that is entered, then the landlord can proceed to evict the tenant. There's no cure option at this point. These are more common. These are common in lease violation cases. So those are the complaint forms 1B or included in a 1C complaint. And these are also going to be the remedy for the landlord if the tenant breaches a move-out agreement. So if you're negotiating a settlement that includes the tenant agreeing to move out of the property, the remedy is almost definitely going to be a non-redeemable judgment if the tenant doesn't move out. So we caution you on non-redeemable judgments. Really never ever should a non-redeemable judgment be a remedy in a non-payment of rent case unless it's being settled through a move-out agreement. Okay? Non-redeemable judgments are obviously they guarantee that there can be an eviction, and so you want to stay away from it because your purpose is to try to avoid an eviction. So just be really careful about what the remedy is in the settlement agreement and ensure that the remedy will be a redeemable judgment in a non-payment of rent case. Yes?
Is there a way to protect the right to the subsidy and in a move-out agreement?
Is there a way to, well, it depends. It depends on the type of subsidy. So if you're agreeing on behalf of a tenant who lives in public housing to move out, then unless it's an agreement whereby the housing authority is agreeing to relocate the tenant to another public housing unit, then you are ending the subsidy, right? They're moving out of public housing. On the flip side, I think often in a voucher case, let's say, if the landlord is suing the tenant, then it may be, protective, and you can include terms in the settlement agreement, that the landlord will provide a neutral reference or that the landlord will forgive all back rent, that kind of thing. So it just depends on the subsidy and the terms of the agreement, but I think that's a good point that you want to think about whether or not the tenant is going to lose their subsidy by, entering into a move-out agreement. I, just generally speaking on move-out agreements, I counsel my mentees not to enter into them or not to counsel their clients to enter into them unless the tenant has already, I just had this conversation with Diane, unless the tenant has already found a place. If they have a voucher, then I want it to already be approved by the subsidy provider, because it is so hard to find housing in DC. You guys may know how hard it is to find housing in DC from your own experiences. So, especially with vouchers, you can get a transfer voucher, but those only last 6 months. The housing authority is being really strict about not extending those vouchers. So just be super careful. I cannot tell you enough how careful to be. So I was emailing with Diane about this the other day, and I was like, we have to have a phone call. And then I was like, sorry, you're just going to have to hear me go off. But be really, really careful about move-out agreements. They absolutely can be the best option for your client, but I think only as long as it's certain that your client has somewhere to go and that somewhere to go isn't going to risk losing the subsidy that they have if they need to keep that subsidy. Okay. Thanks, guys. That's it from me. I think now Beth is going to go.
Good morning. My name is Beth Harrison. I'm a supervising attorney at Legal Aid. And I'm going to figure out how to use the clicker, and then we're going to be okay. Do I just need to click on here? Okay. So we're going to talk about a little more specifically about settlement terms, and we've kind of divided this up to talk about non-payment of rent cases and then terms that you might include in either a non-payment of rent case or a lease violation case, and then provisions that are more appropriate for lease violation cases. You know, I kind of want to say at the outset that distinction's a little artificial because obviously in any case you can be talking about any range of issues involving the landlord and the tenant, whether they are kind of properly before the court in that particular case. But, you know, this maybe will give you an idea of what is typical in a non-payment of rent settlement, what is typical in a lease violation settlement. So, of course, in non-payment of rent, part of what you're probably going to be talking about is how much is owed and whether to reduce it and how much to reduce it. And this is a place where I tell folks to really just run the numbers in a lot of different ways and make sure you're very comfortable with what the numbers are. So here's what, you know, the landlord alleges month by month in terms of what has and has not been paid. Do you have evidence that your client actually paid some of those months? How good is the evidence? Let's gather that evidence. And then figuring out for months when the tenant did or did not pay, what should the abatement be based on housing code violations? In general, in negotiations, but even at trial, I think a lot of us think about abatements kind of across the board. So an across the board percentage reduction for the entire time period that's an issue. That's pretty artificial in the sense that housing code violations often come and go and change. You know, and so it could be that I have a client who one month I would say, really, the rent should be reduced 100% because, you know, the ceiling was falling down in the bathroom and she couldn't even use it, and this and that and the other were all going on. And then the next month everything was fixed, but she still had infestation, and maybe then it should only be a 10% reduction. But at the end of the day, I'm going to say 40% across the board. And in terms of, I would definitely talk to your mentor if you're at the point of trying to think about abatements. I am always happy to kind of look at photos and just give you my kind of gut reaction from my years of practice. But broadly speaking, we tend to see reductions if you go to trial or in settlement that are more in the range of 10 to 40%. When you get to 50% above, those are pretty bad conditions. I just wrapped up a bench trial where we got a 75% reduction in the rent. My client, no human being should be living in the conditions that client is living in. It's awful. It's a property that should be condemned. So, you know, just to give you a sense of kind of the range that we see that are a little more typical. Do folks have questions about that? I feel like I get a lot of questions from attorneys about, you know, how do I figure this out? And it is art, not science. Yes?
When you say for the abatement, are you talking about for the total portion of rent or just for the tenant's portion of the pay?
So if you have, if everybody heard the question, and maybe I should, are we recording this? Okay, I'm going to repeat the question, which was, am I talking about a reduction for the total rent or just the portion that the tenant pays? So if you have a tenant with a subsidy, it should be a reduction in the total rent, not just what your tenant pays. However, and this is something we go over in our longer introductory housing training, and I'm happy to talk about it more if folks have questions. In general, your client is only going to get back the percentage of what they paid. So the landlord should have to give back to the subsidy provider 50% of the rent the subsidy provider paid, if that's what the reduction is. There's a process where the subsidy provider is given notice and a chance to intervene in the case, and only if they did not intervene would the tenant be able to get that windfall. And that's just something that you really want to think about strategically because it will change the math. But, you know, if the subsidy provider, if you talk about it before they intervene as a possibility, you can get some leverage without them actually coming in. Sometimes if they come in, as long as you're not dealing with their part of the rent, they don't care, but you can still use it as leverage to get a bigger reduction in your client's portion of the rent. Did that part just make sense? I don't know how many of you have attended or watched our introductory housing training. Any other questions about abatement? Just kind of the percentage. So what I often do is then kind of run all those numbers and say, okay, well, what if we get a 10% abatement across the board? What if it's 20? What if it's 30? What if it's 40? What if it's 50? Let me look at where those different numbers work out. And then something you want to think about is the difference, if you have both in your case, between a recoupment and a counterclaim. So the recoupment is that claim that you can file that says, I want to get back rent credit for rent my client paid. And there's no statute of limitations because it's an equitable defense. So it goes back to the beginning of the tenancy. So if you have someone who's been there for a long period of time, that may stretch back years and years. Of course, if you try to present evidence at a jury trial of what the conditions were 10 years ago, you may be a little stymied. But, in theory, you could go back 10, 15, 20 years. But the recoupment can only get the client's balance down to zero. It doesn't get money back for the tenant. A counterclaim is what gets money back for the tenant, and that is a separate affirmative claim. And the interaction between them is interesting and not fully resolved. So recoupment has no statute of limitations, although the landlord could raise a laches defense. Counterclaim has a hard 3-year statute of limitations. If you've raised both, the following is not clear. If you apply the recoupment first to try to get the balance to zero, do I start in May 2019 and kind of work backwards until you get to zero? And then you say, okay, well, I applied this percentage reduction, and to get the zero, we reduced rent going backwards, and now we're in May of 2017. And then you say, well, wait, I have a counterclaim, and the judge says, well, that's about a year left, so now we'll apply the reduction to that 1 year, and your client gets that money back. A different way to do it, if I have my client who's been there 10 years, is I say, Judge, the recoupment starts in May of 2009 and goes forward in time until the balance that she owes is reduced to zero. At that point, my counterclaim kicks in, and I get the full 3-year counterclaim, because that counterclaim starts 3 years ago, and then we're going to move as long as these two things have not overlapped. Does that make any sense? If you can kind of picture it visually. So basically, how the recoupment is applied and whether it overlaps with the counterclaim period, either they will kind of cover the same period and you won't be able to maximize them, or you'll be able to convince a judge to separate them in time and they may not overlap at all, which would be ideal for your client. And there's no case law that answers that question. If anybody can come up with a good legal argument as opposed to just kind of basic logic, let me know. When we explain it to a judge, we basically just say, like, look, the recoupment goes back to 2009, you start there. And you just kind of run through it till you get to zero. And then the counterclaim starts 3 years ago, you start there. If the recoupment has already taken out some of those months, then move forward to wherever we are. But you start at the point in time where the claim dates back to. Question?
Yes, you found that judges are more receptive to either option 1 or 2 that you just
I think the idea that recoupment does not have a statute of limitations does not sit well with opposing counsel or judges. The idea that a tenant could come in and say, well, 10 years ago I had infestation, and so I should get a reduction as I sit here today. And so I do think there's a little more resistance to that. I think judges and most of the opposing counsel you will encounter are very comfortable with the counterclaim idea. Like, they get that, it's raised all the time. But this idea that recoupment does not have a statute of limitations is a little less familiar. And so, for example, in discovery, if you ask for things going back 10 years to the inception of the tenancy, you're probably going to get an objection back on relevance and have to point out to them, like, no, I filed a recoupment, it's relevant, I'm seeking information for all these months because that's part of my recoupment. Any other questions for the moment? This last point, there's a case from the DC Court of Appeals called Smith versus Greenway Apartments. It's like 2015 or 2016. I apologize, I forget the year. And that case stands for the proposition, which is the final bullet point on this slide, that if during whatever time period we're talking about, the tenant entered into a settlement agreement or a consent judgment that did not contain a full waiver of claims. So I should be clear, folks in, not just in, eviction cases, but generally in civil litigation, right, all the time, settle claims and sign these full releases. I release everything I ever had forevermore through this date. And so if you did that, you don't have any claims going backwards. But that's not usually what happens in these consent judgments. They usually don't have a broad waiver claim. What the Court of Appeals said is because counterclaims are not compulsory in landlord-tenant court, they are permissive. The way you think about a past judgment or agreement, if it doesn't contain a full waiver, is whatever months were actually covered by that case. You can't claim for those months. You're precluded for those months. But any months before, you could. And that is different than in the way you might think about regular civil litigation where counterclaims are actually compulsory. And so if you don't file them, you lose the right to ever file those claims in the future. Question about that. And so part of what you need to do when you're running the numbers, you need to know what the landlord's claiming, you need to know what your tenant's claiming about what was paid, you need to know what's in the registry, make sure you know what the monthly rent was throughout the relevant time period, but then you need to run your client's name and figure out at this property, are there any other judgments entered into between these parties? And it's probably useful to know if there are cases that didn't result in judgments, because you might show up at mediation, and I've had this happen, the landlord's attorney is like, it can't possibly go back 3 years. We've sued her like 10 times. And then you look, and you're like, okay, you've sued her like 5 times, and it turns out 4 times you dismissed it, so none of that's relevant to what we have here. So it's important to have your hands around those facts as well when you're thinking about settlement in a non-payment of rent case. So in terms of thinking about abatement, I kind of think of this as you're thinking about it from 2 different directions and you hope that they meet. So, there's just kind of this question in the abstract. Okay, I have this case, I have these photos, I look at these conditions, I look at the numbers, what do I think a jury might do? What do I think a judge might do? What does my mentor tell me is within the range of reason in terms of settlement? And that's all fine and good, and it's important to do that exercise and kind of see where you think you are. But then you have to think about your client and what they need and what they want. It may be that you have a client who tells you, based on my income situation, I just can't pay back any money. I really need that balance to get to 0, even though it's kind of big. I have an expectation that ABC will happen in the case. And you want to listen to that, although, of course, our clients' expectations do not always meet reality in either direction. But you really want to think about, what is it going to take to get my client to 0, owing nothing and walking away from this case? Now, let me look at the money in the registry. What's it going to take for my client to owe nothing and get the money that she's paid into the registry? Or split the registry with the landlord, get rent waiver in the future. But think about it in terms of the practical reality for your client. And in particular, I always want to look at that number about what is it that will take the person to 0. And there are cases where that's just not an achievable goal. And you will realize based on the conditions and based on whatever money is owed, that's not, realistic. You'll also have cases where very little rent is owed, and it really becomes a question of how much money is my client entitled to get back when someone has a full 3-year counterclaim. But I think it's important to look at kind of look at the numbers and settlement outcomes and trial outcomes from both points of view, and then try to figure out to make sure they can kind of meet in the middle so that your client's needs and expectations hopefully are lining up with what you think is within a reasonable range for a settlement position, for a trial position. Questions on that? Yes?
Are there distinctions in what you can accomplish between DCHA as a landlord and private landlord on voucher basis?
Yeah, so the question was, are there distinctions between what you can achieve with private landlords where the tenant has a voucher, for example, versus DCHA? So there are a couple, and some of them are actually mentioned on this slide, so your timing is perfect. DCHA in particular files a lot of eviction cases, but frankly is not interested in evicting a lot of tenants. They want to make sure tenants are paying. So, and I'm sorry, when I say DCHA, I'm thinking of public housing. So where DCHA is the plaintiff, those will be cases where it's public housing. And so the housing authority is actually the landlord. In public housing, they often will do very lengthy repayment agreements, $25 a month for, 10 years. And they're okay with that. Now, as you might expect, if you are negotiating an agreement where your client gets 10 years to pay off $5,000, whatever the math works out to be, the housing authority attorney is going to say, we can do this, but I'm not going to abate the rent too, right? Like if I'm going to give your client 10 years to pay back the balance, I'm going to expect that over time they pay back the full balance. And of course, with any lengthy repayment agreement, you just want to make sure that you do the best you can to put your client in the time frame of, okay, this is going to be something extra you pay every single month for a really long time. And if you miss a payment, here's what's going to happen under the agreement. And the typical settlement terms will be, and I know John has some experience with this recently, that if a payment is missed, including rent going forward, that they can bring your client into court on a quick motion. And that could, if it's a 10-year payment agreement, right, that could happen 5 years from now. And so if it's going to be really lengthy, that's the downside, is you really need a tenant who's kind of in the mindset of, okay, I really do have to pay this every single month. It's like additional rent. I need to treat it that way. Private landlords often are not as willing to go that long. And I think, for example, if you have a tenant with a voucher, they can just leave, right? And so you don't have a private landlord who wants to say, well, I'll give you 10 years to pay this back, and 6 months from now you're going to move to another place. They want the payments to be made pretty quickly so that they can get the account to zero. And I do think public housing is different in that way, that folks don't usually leave public housing voluntarily. It's less common. Site-based Section 8 is probably somewhere in the middle. So, and as is mentioned on this slide, HUD has put out guidance that for public housing and site-based Section 8, which are both the programs tied very directly to HUD, your repayment agreement should really be 10% of the adjusted household income and no more. And then also you should be able to have a provision in that agreement that the monthly payment is adjusted if the client's income changes. Now that's up or down, so the payment could go up if the client gets more income. And, I think in my experience, the landlords, private landlords, not DCHA, but the private landlords sometimes are a little more reluctant to follow that guidance. In particular, if you have somebody with really low income where it's like 10% is $20, or you have somebody who's zero income, which happens, right? Right now, nobody's working in the household, no disabilities, no public benefits coming in. And so you end up in this situation of my client really can't pay anything on this balance. You could write an agreement that says if she gets income in the future, she will pay. You could also, and I think Jen's going to talk about some of these issues in the next section, but emergency rental assistance is always a possibility. And you can also consider in tough situations, seeing if the landlord would agree, like she'll apply for emergency rental assistance in good faith and you'll cooperate. If she's denied, here's what we're going to do. And it could be that if it's going to go on for some time, she'll apply this year, and if she's denied, she'll go back in 6 months and apply again, and she'll go back in 12 months and apply again. So emergency rental assistance can really help with individuals like that. We just had a case in our office for someone who was living with her adult son. She had not worked for years. He worked for a while. They didn't get notice of a rent increase, and so they had fallen behind by several months. It was a couple $1,000s. He stopped working. She was still not working. And so they were able to get emergency rental assistance. And thankfully, we had an opposing counsel who we kind of presented to him, like, here's the situation. She's going to go through this process and try to get the money that way because we can't do a repayment agreement because she has no income right now. And she was a steady client, a steady tenant who'd been there for a number of years, and they really didn't want to evict her. So we were able to work that out, but it really took patience from the opposing counsel. It probably took about 3 or 4 months, and we just continued the case until we could see it through to the approval. And then, it's important, of course, if you're talking to your client about repayment agreements, to just be really real with them about can they afford to pay whatever they're telling you. So, sitting down with them and saying, like, okay, here's your monthly income, here's what I'm saying, let's talk about your other expenses, but doing the best you can to just facilitate a conversation with the client about, here's my income, here are my expenses, so what's actually realistic for you to pay as extra each month for an extended period of time, understanding you have to make these payments. Like if rent is your top priority to stay housed, the repayment goes right with that rent. It's equally important in order to keep you in your home. In some ways more so, because there might be a motion that could be filed very quickly to evict you.
So I had a question about the abatement amount. Is there a authority or guidance on how to match up house valuations with their abatement? And do courts really consider that? Do they care about that? Is more just their own kind of guidance?
So the question was, is there guidance about abatement amounts and kind of how to fit that up with conditions, and also do courts really follow that? There's limited guidance, and in my experience, courts don't really follow that. So, the saying that everyone loves to throw around for so many legal things, you know it when you see it. So I think this is true of housing code violations and how judges think about it, and how opposing counsel think about it, frankly. It's not like your opposing counsel is going to kind of pull out case law to argue against you. There's a case from the Court of Appeals that kind of suggests, but doesn't hold and is readily distinguishable, that there's a basic shelter value of 30% of the rent amount if there's a roof. It's not really what the case says, but, in the context of what I said earlier about percentages. So the only time I've ever had opposing counsel cite case law to me about abatement amounts is if you start to get near that 30%, they all know, and they're like 30% shelter value. And in the trial I just had, where we actually got, he only has to pay 25% of his rent, and it's going to go down in a couple months if repairs still aren't made. At that point, it'll go down to him paying 12.5% of his rent, which I believe is going to happen. The opposing counsel articulated that. I mean, we cited back on this slide, in Ray Stancil's a bankruptcy case where the bankruptcy court went into some level of detail. The Office of Administrative Hearings has issued decisions where they kind of go violation by violation and say like, oh, infestation's worth $25 a month. But judges don't tend to look at those, and they're not always going to help you, to be perfectly honest, those decisions. I mean, Stancil's a good decision. The OAH ones, I think, tend to undervalue housing code violations versus how opposing counsel and judges think about it in landlord-tenant court. So, honest to goodness, my best advice is gather your photos together, put them on Dropbox or Google Drive or someplace where your mentor can easily just peek at them, and then just ask your mentor, can you take 15 minutes, look through my photos, tell me what you think? And here's my list. I think those of us who've done it for a while can give you, and you can ask other people, of course, like that's the great thing about having it all collected together is you can also, if you were doing a jury trial, I would tell you, like, ask 10 different people in your office, some who are not lawyers, and frankly, the jury pool probably looks more like your office than the community in which your client lives, in terms of who shows up for jury service. So, but it is, I think, very much an art, not a science, and you just have to get kind of reactions of folks who know. And I think when you're in the settlement posture, to me, talking to your mentor is particularly appropriate and helpful because we probably have a sense of opposing counsel and how they will respond. And I can even customize it to who the attorney is, right? So I can say like, oh, that attorney, going back to Jenny's story, like, oh, they never respond to oh, they hate discovery. So like at this moment, here's what you need to do because he really doesn't want to do discovery with you. So, reach out to your mentor and try to get that customized advice.
Can I ask one?
Yeah, please.
So I also think that a lot of judges can be persuaded not just by what is the housing code violation and how would it impact the average household, but how does it impact this particular household. So I once saw a judge, there was a window that just didn't stay open, it would slam shut, and the judge was like, and there were children there, and this was not a tenant-friendly judge, and they were like, yes, there are children there, and he was like 50% abatement. Like that to me was just horrifying, but if there weren't children there, I don't think they would have gotten, maybe not even a 5% abatement. So I think also explaining how your client's household is impacted by these particular violations, if that's persuasive for increasing the abatement, is very helpful.
I had the same thing happen with a missing window screen and small children. And I was surprised because we were thinking like missing, I mean, you know, like half of my clients don't have window screens where they're supposed to. What's the big deal? So yeah, no, it's a great point. Anything else? You know, you can think about waiver. You always want to look not just at the rent on the ledger, but late charges, court costs, other damages charges to try to get all of that wrapped up in a settlement agreement. If you have a client who's going to move, and we'll say a little bit more about this in a minute, getting back a security deposit that's been paid, getting help with moving, like first month's rent or security deposit in a new place. And you can think about there, you know, can we release money in the court registry for that purpose? Or if my client's moving out, you know, she's going to move out in 6 months, don't make her pay rent for 6 months. That's so she can save up this money along the way to cover the moving expenses. And if you're talking about payments for vacating, it can be helpful to sit down with your client and try to come up with a list, you know, so that you can articulate to opposing counsel. Well, we think a security deposit might be this much for a new place. You know, first month's rent will be about the same. If she were to hire a truck and do this and the other, would cost this much. If she were to get a storage unit, it would cost this much. So just trying to make your request a little more concrete. Here is why I'm asking for the number I am asking for. So in general, if you're settling a case with a payment plan, what that is usually going to look like is the landlord can file a motion for a redeemable judgment, so the tenant would still be able to pay, but they would have to pay the entire balance at that point if there's a missed payment. And usually the agreements do cover the rent as well. And, you know, the reason is probably obvious, but basically the landlord will articulate to you, well, I don't want her paying just the $25 and she doesn't pay her rent and I have to file a new case and you jury demand it. Like, that doesn't make sense. That's not the point and that's not fair. So if we give this extended payment plan, she needs to pay not just the $25, but the rent going forward, whatever that is. You can certainly, especially with a longer time frame, try to build in some protections like, you know, okay, if the tenant is late but pays during the month it was due, the first time that happens, no motion. The second time that happens, motion, or the third time it happens, that's when you can file a motion. And then in any kind of motion for a settlement breach, I always try to ask for more time than the landlord-tenant rules. Landlord-tenant rules say 10 days. It's not the way it's playing out with electronic filing, some other stuff with calendar management that they're trying to deal with. It's been longer than 10 days for most motions. But just making sure you get a guarantee, like it's going to be 3 weeks at least, so you'll have time to respond, talk to your client. And then I try to put in, you will immediately fax or email the motion to me. I will say with electronic filing, that's less relevant because the landlords are all subject to electronic filing. And so unlike, for example, legal service providers, unless they're pro se. And so with electronic filing, you will immediately get a notice when the motion is processed by the court and docketed. But you can still consider whether you would want, there may be a delay between when they give it to the court and when the court goes through all the processing for electronic filing of a couple days. And so it still could be useful to get it as soon as they are handing it off to the court so that you'll know. Yes.
How important do you think it is to push back against consent judgment? Have you seen any creative ways to like make it easier for the landlord or more amenable to the landlord?
So the question is about consent judgment versus consent settlement and the landlord's objective that I have to make a little bit of fun of. It's so hard to file a motion. So there's a court form with a consent judgment that's an application that terminates day. It's a one-page form. There's like a blank space where you fill in the date of the payment that was missed and like a checkbox or something, and you sign on the bottom. And so that's why they like consent judgments, among other reasons. But I think actually it's the primary reason is they're like, there's a court form and it's 1 page and I just check and then an emotion is like 5 pages.
We tried to draft the motion for her.
Yeah. I mean, they have form motions, right? Like, so I mean, I would try to push back a little on the rationale, saying, I get it, like I get that this is, you know, but let's be honest, it's not that much more work for you to file a motion. And I will say the way the court is treating applications to terminate stay on a consent judgment used to be they were expedited in terms of a hearing date. They're not doing that anymore. And so some landlords' attorneys may not have kind of in their mind made that transition of, oh, right, the court now makes us give at least 10 days for those two. It's not quicker in terms of a court date. And you can point that out and say, it's my understanding under the way the court's processing these now, it's not that you're going to get an earlier court date. It's just that you'll have to file like 2 more pieces of paper. And I kind of like the idea of like, we could even draft the form motion for you and hand it off to you as a Word document, you know. Doesn't matter for the tenant. Consent judgments look worse. You know, I think most of us who represent tenants have a fairly visceral reaction to consent judgments. You know, that said, I think based on my experience in the court, you know, it depends on the judge. Some judges will view a consent judgment a little more stricter, you know, will interpret it stricter. Some judges won't, and will still allow some leeway, and vice versa on settlement agreements. I mean, you'll have judges who will look at a settlement agreement and say, you know, it says the payments were supposed to be due by this date and you didn't do it, and it's very straightforward, it's a violation. So, you know, I think in the end, my line is I don't do consent judgments. The only time I've done one in a full representation case was kind of very unique circumstances, and we did it such that the judgment would be vacated at the end of the case if he complied with the agreement. But, you know, I think you can think about the pluses and minuses, but I would certainly argue back, and those are the arguments I would make. You know, sometimes staff attorneys in our office will just say, because it kind of helps them in this situation. Obviously, pro bono attorneys can't necessarily do it. I mean, you could, but they'll say, well, legal aid just has a policy that we don't sign consent judgments. I'm sorry. I think LCE may use that kind of technique too. We just say, it's our office policy. We just don't enter them. I'm sorry. Yeah. So, I mean, I think you to think about it, and I don't think this necessarily resonates with opposing counsel, but and if you've been on a court tour with me, you may have heard me say this. You know, it's rare in civil litigation as a defendant that you agree to judgment, that it's a consent judgment as opposed to an agreement. Sometimes consent orders or consent decrees, that's fair. And of course, what's terrible about landlord-tenant court is that most tenants are unrepresented and agree to a consent judgment on the very first day without talking to a lawyer, without raising any defenses. And this is a little different if you're talking about at the end of a full representation case. I think similarly, it's just there's no reason. Like, why should my client agree to judgment? If they violate the agreement, yes, you can get your judgment, but like, why? And I will say, at the end of the day, if it's lifting the stay on a judgment versus imposing one, a judge may be a little more reluctant to impose the judgment without a second chance as opposed to lifting a stay on a judgment that's already been entered. So I think it can have a practical effect in that way. I'm sorry, that's my phone ringing. I'm not going to answer it, but I apologize, it's making noise. So repair provisions, you could include these in a non-payment of rent case, of course, where you guys have talked about housing code violations, but if you've gone to our introductory housing training, part of what we say is if you have a lease violation case, ask your client about repairs anyway, because odds are the client needs repairs, even though that's not an issue in the case, and you can include them in a settlement agreement. And so I would definitely encourage you to make repairs something that you're talking about throughout the case, whatever type of case it is. So it's a good idea to have some third-party verification, even if it's just somebody in your office or you personally going out, but not necessarily just relying on your client, because the client may under or over report, but also because in mediation, it will, in settlement discussions, it will give you a little bit more leverage and credibility to say, hey, I went out to the property, I saw the stuff, or my legal assistant went out, they provided me with these photos in this list. When you are writing up what needs to be repaired, you want to be as specific as possible about what needs to be fixed, how it's going to be fixed, and then when it will be fixed, what the time frame is. But for example, if you have broken blinds, you don't want to just say repair the blinds. You want to be specific if you think they need to be replaced and say replace the blinds in this room, so that they don't try to do some kind of Band-Aid repair, which is not really what you want. There's sample language you can get from your mentors about things like repairs should be workmanlike. If a license is required for the contractor who's going to perform it, then that person needs to be licensed. Time frame of when they can be made and so forth. And then you want to think about, so you're going to have an agreement that says landlord will make the following repairs in this time frame. How are you going to verify that? So it could be that the parties do a walkthrough and then they agree to some kind of hearing or motion process if there's disagreement. It could be that you rely on a third party like DCRA, the Department of Consumer and Regulatory Affairs, and you say like, hey, if they come out and they continue to cite violations, you'll have to fix those. The quality of those inspectors varies, so I would think about that if you're going to do it. But if you're really running into loggerheads where the landlord's like, you're just going to keep saying we didn't repair things because that's what she says every time, that may be a way to cut through that and say, that's fine, we'll just rely on a government inspector. But when they say that you haven't fixed it, you're going to have to fix it. So you can think about that. Another thing that you may run into is, you're at mediation or you're negotiating a settlement, you have your list of repairs, and the landlord's attorney or the landlord representative is balking and saying, like, I don't believe that these 5 things are a problem. And you have pictures, and they say those pictures are old or whatever. And so one thing you can do is have both sides do a walkthrough to come up with that list for the settlement agreement. And if you're at mediation, you might want to suggest, why don't we continue the mediation for 30 days? Let's schedule a walkthrough. I'll be there. You can be there. My client will be there. Your client can be there. And let's literally just walk the unit together. And let's look at each condition and let's talk about how it's going to be fixed and whether it's a problem. And so I have found that to be, it's a little time consuming. And my preference first is always to come with a list of repairs and say, here's what it is, you need to accept it, and here are the photos that back it up. But, again, if you're butting heads over that issue, that is a pretty effective way to cut through it. And you will find in, 90-something% of cases, the landlord's attorney comes to mediation and has never been through the unit. And so, it's easy for them, if their client is saying, these things aren't an issue, it's easy for them to accept that. It's a little bit harder if they're standing there in the unit looking at the conditions that you've documented. But a lot of attorneys can be persuaded by photos, so I definitely would try going that route first. If there are inspection reports, of course, use that. And there are ways to look up online if DCRA has been out there. If the person has a voucher where DCHA inspects, you can find out from DCHA, have they inspected and where do the reports show. And then in terms of repairs, just remember, housing code violations are the easiest thing. Like, this is an actual violation, you need to fix it. But you can talk about things that are not violations and whether or not those could be addressed. And my 2 favorite are on here. So there are like, 10 like urban legends about landlord-tenant law in DC. And one of them for tenants, and one of them is my carpet has to be replaced every X years, and that's somewhere in the DC housing code, and they're violating it, which is, there's nothing in the housing code about replacing carpet every so many years. Similar about paint. I point that out to say it is very meaningful to tenants often to have their unit repainted or to get new carpet because it's not strictly required under the housing code, and it becomes a real point of contention with landlords where you walk in and you look at the carpet and you think like, no family should have to live with carpet in this condition. It's disgusting. It's beyond where it can be cleaned or really fixed. It just needs to be replaced. And it hasn't been done in 10 years that my clients lived here, but the landlord isn't doing it. So that can be a really meaningful thing for your client in settlement, is to get the landlord to agree to do that. But there may be other things as well that your client says, what I really want is X, even though it may not be required by the housing code. Yes, oh, good. Okay, thank you. Lisa's telling me I have 10 minutes. We're gonna get there. So you want to talk to your client about access. Make sure that your client is going to be ready to provide access. You can pick out specific dates and times, of course, but you can also, if that's not possible, say, look, you're going to give my client 48 hours notice by texting her cell phone. It can be Monday through Friday. It can be 9 a.m. to 5 p.m. And there is law that was enacted in 2016 called the Residential Lease Clarification Amendment Act that has some limitations on access that you should, and notice that you should look at if you're running into problems with that, where you can say, look, this is the minimum required under DC law, so you have to at least agree to do that. Usually for repairs, you'll just put in a provision that you can file a motion seeking specific performance in order that the repairs have to actually be completed. And then, of course, once you have a court order, you could get sanctions if the order itself is not complied with. The court has changed its approach in letting, once a case is settled, letting tenants continue to pay into the court registry. So it used to be that we would try to use that as leverage, but we found now that the court is really blocking that in settlement provisions or not allowing those payments to be made. So, but one thing you can do is if you go to a motion hearing, say to the judge, we want you to order that the tenant can start paying her rent into the court until the repairs are done, and then we want to have another hearing about what happens with that money that she pays into the court, which was not, part of the case and part of settlement. Questions about that? I thought I saw a hand.
So for the consent judgment, I understand, my understanding is that the plaintiff can just file their judgment in the court and will be evicted in however many days it is. Is there a similar mechanism to be built into the settlement agreement where the landlord is actually making payments to your client that you file this judgment or
that would be nice. There's a lot packed in your question. So the question was, your understanding is under consent judgment, the landlord can just file something and proceed to eviction. Could you put in settlement the landlord has to make payments to your client, and if they do not, similarly, there's some summary process. So first of all, I would say on consent judgments, it's, the one-page application to terminate stay I was talking about. It takes a couple weeks to get into court. You do have to have a motion hearing. You can raise defenses. The eviction process itself in DC, just to give you guys an idea, is roughly speaking about 30 days from when a judgment is entered. And the process now, which is a change within the past year, is they schedule a specific date. I think you can always try to negotiate for very specific remedies of what happens if the landlord does not do what is required. And so you could negotiate something if they're making payments to your client, or just one big payment to say, if this does not happen, I get to file a motion, and you agree that you will pay a penalty of $50 a day for every day you did not make the payment past the deadline. I think it's often hard to get parties to agree to that. That is certainly what you should think about if you have to file a motion in terms of what you're asking the judge to order. And so when we get to the point of a judge ordering something because the party has not done it, even at the first hearing on my motion on forced settlement agreement, I'm saying to the judge, I want an order not just that the repairs be made or the payment be made, but I want you to specify it has to be done by X date, and here's the penalty every single day after that it's not done. And then we're going to come back, and if it's still not done, I want you to ratchet up those penalties. And you can throw in attorney's fees at that point, because, of course, you're having to come back to court and do all this stuff. A colleague of mine who's now a judge, we had some cases where we had the situation of agreements in 5 related cases that weren't complied with, and we ended up coming back to court 4 or 5 times. But we followed this approach, and our clients ended up getting tens of thousands of dollars in damages paid to them for noncompliance. We got attorney's fees. They just could not figure out how to do what they needed to do to comply. And so, and eventually they kind of had to because the money was ratcheting up. But in the end, it was something like $30,000 or $40,000 they paid, because they couldn't figure it out. So judges, I think, are open to that once you're in court and say the person hasn't complied. Does that help answer the question? Kind of. And actually it mentions this at the bottom, think about building in the penalties even up front, or certainly asking for it once you're in court. I've already mentioned the idea of asking for a longer time frame for a motion, and that the motion be faxed or emailed right away. You also can think about requiring for any motion, and this is just a more general point, that there be informal discovery, so the landlord has to tell you all the witnesses or give you all the evidence they're going to use. And you also can think about putting in an agreement that if the tenant has to do something, that they get some period of time to fix the problem before the landlord gets to bring the tenant into court. So, you know, if, as an example given here, if you're promising that your client will keep their unit in a sanitary condition, then you say, okay, the way this is going to work is you do an inspection, you give her a notice, she has 5 days to fix it. If she still hasn't fixed it after 5 days, then you can file your motion. This is 48 hours, which is probably more realistic. So move-out agreements, Jenny already talked a little bit about this, but you really want to just caution your client about it, caution your client from making quick judgments on this or getting frustrated and just wanting to leave. Because the DC housing market is rough. And so talk in a minute about the possibility that you'll lose your subsidy if you move out. But, you know, just in general, you really want to talk to your client about where are you going to go, how long is that going to take, you know, have you looked at how much units cost and so on. You want to make sure you fully understand the merits of the case. Can you file a dispositive motion and potentially get it dismissed? You know, what can you do to put pressure on the other side so that a settlement short of move out is a possibility. And just a reminder that a landlord saying, you know, the lease is about to expire, so your client's going to have to move anyway, or I don't want to be in the voucher program anymore, so I'm going to get rid of your client. Those are not reasons that the landlord can actually evict a tenant. And so if they say that, that's not something that should concern you. When you're talking to your client about moving out, you really want to talk in as much detail as possible. You know, how long is it going to take you to move? What's it going to cost? How are you going to move your stuff? You're going to pay somebody? You're going to hire a mover? You're going to get a truck? Let's talk about how that's going to cost. How long does it take for you to get that lined up? Where are you going to go? You know, I'll go stay. No, like really, tell me who you're going to stay with. You know, is it a relative? Is it a friend? Have you talked to them about it? How long are you going to be able to stay there? And that kind of goes to, you know, usually staying with a relative is not plan A, but what is plan B? So you say you're going to find a unit. It's going to be approved by this date. Hope that works out. If that does not work out, what are you going to do to make sure that you're not actually evicted? Where are you going to go? And you just want to try to help your client be as realistic as possible about the costs and timing of moving. If you want to look in neighborhoods and get an idea of market rents or kind of market rents, DC Housing Search is a website where you can look by neighborhood, ward, zip code, and just kind of look at some things that are up as listings. And so that might start to give you a ballpark, like, hey, if you want to stay in this neighborhood, I'm seeing rents at this level. And even for a tenant with a voucher, that can give you an idea. Okay, you have a voucher. Are the rents in this neighborhood going to be, you know, within the maximum amount that the housing authority will pay on a voucher? If you do a move-out agreement, generally what this is going to look like is one of two options, or potentially the third, which we don't like. So one is just you say, hey, my client's going to leave by June 12th, and if she doesn't leave, you can file a motion. And the landlord's attorney is going to say, that's ridiculous. She's moving out. I shouldn't have to then file a motion and wait 3 weeks to come into court, and she just gets to live there rent-free. And so something that I don't do generally in cases, but with a move out, I am more willing to do, is you say, okay, fine, she's going to move out on June 12th. Let's set a status date in court on June 14th or June 17th. I don't like to do it the very next day, because even if it's like a 5 p.m. deadline, things may be a little in flux in terms of everybody's understanding of the facts if it was all happening at the last minute. But, you know, we'll set a status hearing and we'll write into the agreement that if you can show at the status hearing that my client still has not moved out, then you will get a judgment at the status hearing. And this is responsive to the complaint of, you know, I don't want to file a motion, it's too much work, I have to wait too long. So that's a way to give them quicker relief. And then the other alternative is consent judgment with a stay. So we talked about consent judgment. I will say, because the application to terminate the stay on a consent judgment now gets scheduled just like motions, so it'll be at least 2 to 3 weeks out, the status hearing option will give the landlord a judgment quicker. And it will be even easier than them filing an application to terminate stay. So they should be willing to do that, even if it's several days after the move out deadline. And you just want to talk through that with them and argue with them about why, practically speaking, that makes sense. And then sometimes landlords will ask, hey, can we just say that after June 12th, if she's still there, I just get to change the locks? Or, you know, I will automatically be able to come in and get a writ on June 13th when she's not out. And it is our strong recommendation, for probably obvious reasons, that you never agree to something like that. You do not want to agree to self-help eviction, in other words, eviction without a court process. You do not want to agree to something where there's no motion hearing. You know, even if it's a simple question of did the person move out on time or not. You know, if the move out deadline is June 12th and my client is in a terrible car accident on June 10th, I want the opportunity to say to the judge, if the landlord denies an extension, here's what happened, here's why my client didn't vacate on time, we want more time. And I want to see a judge about that. I don't want it to be an automatic process. So keep that in mind, because sometimes landlords' attorneys will ask for that. And then if the tenant is moving out, terms we've talked about before, but of course you want to try to get waiver of any fees that they might owe, including rent, return of a security deposit if they paid one. You want to talk about moving expenses and getting them some money back, potentially a payment. And then the last thing is what we call a neutral rent reference, as opposed to a positive rent reference, which most landlords who have sued their tenants for eviction are not willing to do. But a lot of landlords will be willing to be neutral. And so they'll write a letter that says, you know, Beth Harrison was a tenant of mine from 2010 through May of 2019. She left voluntarily. She was current in rent and all of their charges when she vacated. She has agreed to leave voluntarily. She is currently, you know, up to date in rent or all their charges or whatever. And then you can say in the agreement, if you want to, the landlord will not provide any additional information even if requested, and they will only provide that information if they are contacted. And then finally, just a couple points about lease violation cases and what might look a little different in those. So usually here, you're going to either have a case dismissed, which is awesome, of course, have what folks commonly refer to as a good conduct agreement, where the tenant says, I will not do bad thing X, or I will do good thing Y for some period of time, or possibly a move-out agreement. So dismissal is something, you know, that you may be able to push where they don't have any evidence the conduct has continued, they don't have any evidence the tenant hasn't cured. You may feel like you're really well set up for those or other reasons for a motion for summary judgment. And so you say, look, I could file my motion for summary judgment. I can make you respond. I think I have really good arguments. But we also could just agree to a dismissal before we have to go through discovery and you responding to the motion, doing all that work. Or possibly if you have some other kind of complete defense, like a reasonable accommodation. You have a tenant with a disability and you say, look, my client has a really strong claim for reasonable accommodation. Let's put the reasonable accommodation in place. Let's kind of fix to the extent we can whatever the problem is, and then I want you to dismiss the case. And we move forward, and if problems arise in the future, you can always file a new one. So you want to think about that and whether dismissal is possible. Good conduct agreements, you know, are great, of course, if a tenant can comply. So you want to be really, you know, again, have a really frank discussion with your client about that. And I would say in particular, if there's alleged conduct that's being engaged in by somebody else. You know, my son, my sister who lives with me allegedly did ABC. Okay, so how do you know that your sister is not going to do ABC in the future if that's what we promise? What steps are you going to take? What control do you have over the situation to ensure that this other person does not do this thing that we're worried about? And, you know, on occasion, I have talked to my clients at certain points in time about, like, look, you know, this other person in your household is what's really going on. Do you think it would be appropriate and helpful for me to sit down with you and that person and we can talk about this and talk about what's at stake in the case? Talk about this agreement you're thinking about signing and what's going to happen if you sign this agreement and then a bad thing happens. And so you can think about that as an option. Of course, you know, in a lot of families, as in all of our families, probably somebody else coming in to play that role may be helpful or may be the last thing you want. But I think, it's always worth thinking about that and offering that, because you may have a client who says, I'm not sure they're going to listen to me, but maybe they'll listen to, a lawyer. So think about that. Usually on good conduct agreements, the time period we see is something like 6 months to a year. That's a long period of time sometimes for particular conduct. And so when it gets to be longer than that, I get nervous. And so, of course, you want to limit that time period as much as possible. Sometimes I'll point out, if we're pretty far in the case, I'll be like, look, the issue is unsanitary housekeeping, allegedly. Well, we're 6 months into the case. You guys have been in the unit several more times. You haven't found bad conditions. And so, asking her to now go a whole full another year really just isn't warranted. Let's do 6 months, because you've already seen for the last 6 months she's been able to do it. And then, of course, you want to be as specific as possible. So, don't do these broad, she will not disturb other neighbors. Try to narrow it in. She will not, assault another neighbor. Instead of saying no noise, she will not cause noise that is at a level that disturbs one of the other residents after 10 p.m. at night. But, something where it's very specific. And then you can then bring in that idea of, at a hearing, you have to tell me who the witness is, you have to give me evidence ahead of time, you need to have somebody with personal knowledge there to testify, because if you craft an agreement like that, it will be a lot harder for them to prove a violation. And so you can also talk about how the landlord can prove a violation. For example, if it's disturbing other residents, the landlord has to bring either a resident to the hearing to testify about that. So, and then finally, usually in these agreements, the only remedy that's really possible, which is why you want to be cautious about what your tenant is promising, is a non-redeemable judgment after a motion. And so that, of course, is the most serious of penalties in landlord-tenant court, because the client will be evicted, the client will not be able to pay or do anything else to stay. And so that's why you really want to think about all the protections you can, not only on what the tenant is promising to do or not do, but what the process will be if there's an allegation that the tenant has violated the agreement. Questions? I went a little over time, but I want to make sure if folks have questions about any of that. All right. Yes?
I have a question about mediation versus settlements, I guess, out of court or without mediators. Do you have these as pros and cons, and you find that mediators actually help, or do they then have maybe a landlord and bias?
Yeah. So the question is about mediators versus kind of out-of-court negotiations. So I will offer a couple thoughts. One is, you may find that your opposing counsel just will not engage in settlement negotiations until you sit down in mediation. And, there are various ways in which the high volume nature of the landlord's practice, may or may not kind of interfere with having productive settlement negotiations. And so sometimes that's just a challenge, that you reach out repeatedly and they just will not focus on the case until they have to show up in court. The mediators are good and bad. There are some mediators that we get in a room with, and I think you are doing damage to the cause by what you were doing today. But there are mediators who can be very helpful. And I also think, there's situations where the parties are butting heads, where having any third party in the middle just kind of help you talk through issues, helps you make a breakthrough. And part of my advice about that would be, the mediators are really good when you meet with them alone about respecting your wishes and what you say to them. And so you can say to them, I want to give you my sense of this case. Here's what I think is going on with the landlord and the landlord's attorney. Here's what I think the issue is. Here's what I think they're not understanding. And so I'm telling you all this with the hope that you could help break through that issue. And then if you want to, you can say, and I don't want you to tell them that I said all that, but I thought it might be helpful for you as a mediator to know my perspective on why we're not able to settle, even though we really should be able to. And so, I would be as direct and candid as it seems appropriate and you feel comfortable with the mediator when you're alone with them, and try to use the mediator to help you get to a resolution by identifying things that are blocking settlement, things that maybe the landlord needs to hear that they don't want to hear. There's a way to do that for your own client too. you know, Miss S is telling me she's very concerned about da-da-da, but my concern is da-da-da-da-da when you're alone. You know, and then maybe the mediator helps facilitate a conversation as the third party who says, well, Miss S, let's talk about this. And then, of course, at the end of all that, you can say, no, we don't want you to repeat all that to the other side, of course. So does that help in terms of kind of the mediators? I mean, I very much encourage folks, reach out and try to do settlement negotiations before you sit down for mediation. Come into mediation very prepared to settle. And it goes back to the point about leverage points, because there are moments before mediation, discovery's overdue, and so forth, where you may have a lot of leverage even before you ever walk into a mediation room. And so you don't want kind of the artificial calendar of the case to interfere with you trying to maximize those leverage points when they're coming up. Any other questions?
Who are these mediators? It sounds like you trust them. You say that things don't tell the other side, like you say.
I do trust them for that because it's part of their training. I mean, there might be one or two that I would say. They are, you know, experienced attorneys with all kinds of backgrounds who do this on the side, and many of them do it not just in Superior Court, but they may do it for administrative proceedings at the Office of Human Rights in DC or other places. They may do it in federal court. Their knowledge of landlord-tenant law varies widely. You know, and so that's part of, sometimes I think when we run into trouble, it's either a mediator who kind of thinks they know better, you know, and kind of takes an approach to mediation of like, my job is to tell you how the case should settle, you know. And there are some mediators where the issue you'll run into is you will be telling them something about DC law that's very unfamiliar to them, and they will have a hard time believing it or like pushing the other side on that point. So, you know, the landlord's saying the lease expires next month, so the tenant just has to leave. And you say to the mediator, that's just not how it works in DC. And the mediator's like, I just don't understand. And they're not going to push back hard against the landlord because, you know, they themselves are not getting it. So we see that as well. But I think, you know, and you should ask the other folks in the room who are asked Jen and Rebecca for their opinions, because we have some who are bad. But I think a lot of them are kind of a little too very helpful. Yeah. So I'm going to turn things over to Jennifer Berger from Legal Counsel for the Elderly. Our contact information is somewhere in the materials. It's on the first slide in the slideshow. Thank you. Second slide. Awesome. And we have our binders with sample settlement agreements that have been passed out. All of us will probably say this, but you'll have your assigned mentor, but you can always feel free to reach out to one of us, especially if you don't have a case right now, if you want one, if you just want to come on a tour or something, just, you know, reach out. We're always here to help. Thank you guys for coming.
Good morning, everybody. I'm Jen Berger, and for the past 13 years, I've supervised the eviction prevention team at Legal Counsel for the Elderly. That shows you how fun it is. I'm still smiling. Don't seem burnt out or anything. It's really good work. So just to add to Beth's point, I find that I have to sometimes take control of mediation. There's one mediator particularly who, I don't know if it's because he's anxious, but so I'm going to display empathy toward him, but he gets my clients really freaked out because he starts kind of raising his voice, and the first thing he starts with is, so when do you want to move? And so I'll say, can I talk with you outside? And I tell him, if you're going to start out with what the landlord would already get if my client never showed up and if my client never had counsel, then this isn't going to work. And I've had times where I've had to say to this mediator, you know, because they're rushing us time-wise, if you're not able to devote the time necessary, maybe we can continue this and have another mediator. And I have no problem doing that because this is our client's opportunity to resolve the case. And when your client hears someone else making judgments about the merits, it can kind of psych your client out, and then they may end up settling for something much worse. I mean, we obviously have to work against that and counsel our own clients. And taking a client in another room is really critical to counsel them alone about the issues in the case and the positions that are being taken, because the other side will posture as well, and that doesn't mean that your client should give up ship as to what they want. So let's talk about creative approaches to settlement. I am all about creativity. I think most of what I do is trying to solve problems that are unique. Our client base has a lot of different issues that arise from their physical and sometimes mental health disabilities, and we have to tailor the settlement to what they need. And it's really important to get to know your client very well in non-stressful situations. Sometimes it entails visiting clients to figure out what they want when they're not stressed out, because they will be a little more stressed in mediation. They'll view that as a court proceeding. So in terms of pretexts, this just happened recently. Landlord, it's a non-payment of rent case, and there's not a ton due, and I think it's fairly straightforward to resolve on its face. But then there's a history I saw. There were a number of court cases relating to my client, and there's a long relationship with this landlord. I asked my client if it would be okay for him to wait in the hall for a moment, because I talked with opposing counsel separately about the case. And this is a case I got very last minute. It was in a trial posture, and I thought he'll do better with somebody than not. So let's see if I can try to come in late and try to resolve this. So the pretext of the landlord wasn't to get the rent. It was to resolve this very tenacious issue that he had with the tenant. He felt that the tenant, true or not, was butting into the business of all the other tenants in the building and criticizing him as a manager. And my client's pretext wasn't about the money. I was talking about money and how much would you want, and focusing on that initially. His pretext was safety and security. He was very, very into cameras working in the building, lights being on. So in terms of settlement, a settlement that didn't include that would have been a big issue. So that's what we're talking about when we're saying, look at the pretext. Understand the psychology of it. For those of you who studied psychology, it's a lot of people skills. It's a lot of listening to the other side, even if what they're saying may offend you. Sometimes what they say is actually violative of the Fair Housing Act. They're saying, well, your client's crazy. Your client needs, and the opposing counsel will say that, and I'll just sit there and school them on the fact that they have to accommodate disabilities of a client. But these are the different conversations that will be important to have, which points to having a lot of time for settlement conversations along the way. Normally you have, as was discussed at the beginning of the training, you have a lot of different points where you can get information, and having discovery back will help you understand what the pretexts are. So settling before getting discovery back is not always recommended, or typically is not recommended. So, maybe the landlord wants to sell the property, and no matter what numbers you're throwing, it doesn't really matter. And we've seen a lot of cases like that, particularly look where your client lives, look at the value of the building, and know the area to think about whether gentrification is affecting the desire to push people out of the building and sell the building vacant, because buildings are more valuable vacant. So in terms of remedies that will actually help your client, if your client decides they want to move, then having the security deposit, Beth was mentioning before, the money to move, that's important for your client, making sure you understand if your client could even comply with a good behavior agreement. And you have to get to know your client to know whether that's the case, particularly in cases involving mental health issues. You want to make sure your client's getting help. If they've never been touched by mental health treatment and you then go forward and try to do a contact agreement, that's going to be really, really difficult to settle the case in that situation without knowing more. So it's really important to think about talking with your client ahead of time outside the mediation context, well in advance from the initial meeting with the client, ongoing, about what they want. And let's talk about some ideas. We don't want to leave you without any ideas, but just know you can be creative, and you should talk with your mentors about the case to see if your idea is founded or whether there will be legal impediments to you're implementing the idea. So the settlement agreement could be conditional. For instance, I don't like to make the agreement contingent on getting rental assistance by X date. I always talk with my mentees and supervisees about the fact that you need to start that rental assistance application really early. You want to have a backup plan if rental assistance doesn't go through. They do tend to run out of money starting July, August, when the fiscal year is coming to a close. Fiscal year, of course, meaning end of September the year is starting October 1st. They'll get new money, but not quite right away. So that's another thing to think about. If you're getting the case in September, the money may not come in until close to Thanksgiving, just before Thanksgiving. So these are the things to think about. Rental assistance, but in the alternative, if they don't get rental assistance within 60 days, a repayment agreement will start at $25 a month until the rental assistance kicks in. So we'll also take monitoring your case after the settlement to make sure that everything goes through. And that will be a particularly good way to involve, for instance, legal assistants in your office who want to do pro bono work and don't always know how they can get involved. It's a great way to involve them in that process as well. Having other chances, particularly with people who have chronic mental health issues. We have clients who have hoarding issues. We don't even enter settlement agreements until the apartment is actually clean, and we have home health aides in place. And that's all that what you can get the extra time through reasonable accommodation requests. So that's also something to think about. If someone's going to promise to clean their apartment and you haven't gone in there to see it yet, which I don't think it would be the case, but you want to make sure you know what you're dealing with. If you go to visit and the door, you can't even open the door, then entering any kind of settlement agreement really early is going to be a problem. Any questions thus far? I know you've had a lot of information. At any time, you can stand up and stretch too. I've seen you sitting here for a while. So we've mentioned this a couple of different times, but making sure that you're enhancing your client's stability, getting them supports and money if they do decide that they want to move. I will talk about move-outs a little more, but it will be really, really important not to enter into a move-out agreement without having a place lined up, ideally, because it's really hard to find an affordable apartment. So settlement pitfalls. You should think about what the landlord's asking for in the court complaint, and it's kind of like what I was saying about that mediator who was very difficult. They're asking for a judgment from the outset. They're saying, when can you move? But the client actually has a counterclaim for rent paid where there were repair issues and there should be a rent refund. Then the landlord shouldn't get more than they normally get. They shouldn't get a judgment right away and all the rent due. Like, if somebody's going to move or a judgment's going to be entered, then the landlord shouldn't be getting any money. I don't like entering judgment at mediation. It's similar to death. The consent judgment recipes are for very extreme circumstances. The only one that I entered, I remember running into Beth in the court building. I said, I feel really awful. I'm about to do something. I'm going to check with you for a second. It was like $18,000 that the client owed, and they were in public housing, and they otherwise would not be able to pay the lump sum. Rental assistance would pay up to $6,000, and that was something we did, but the client is still housed. They happen to have been still paying, and it was like a $25 a month repayment agreement. So sometimes that does, you have to do that in order to keep your client housed, but it's very, very rare. Other settlement pitfalls, you want to think about what would happen in trial, and I understand that you may not have experience with doing a trial, so talk with people who have. All of us, as Beth mentioned, are happy to talk with you. We never want to step on your mentor's toes and give advice that's contrary, so I often will say, who's your mentor, and get in touch with them and say, what advice have you given thus far? But I'm happy to do calls with people just to say, I've done several trials on this issue. In Ray Stansel was a case that I litigated with a team of people years ago, and it was an extreme case. So when you're talking about abatements, looking at those abatements, it's just so unusual. There was lack of heat. There was a woman who was pregnant who didn't have an operational toilet. I mean, there's all sorts of things that were very unusual about that case, but we do have a sense through other litigation as to how much abatement would be possible, and it's important to think about that before signing any settlement agreement, so that your client can make decisions that are clear-headed before you step into the mediation room. And then the other thing is trial. When you go to trial, say your client owes $2,000 and you've done an escrow at your office, which we have, it's only over the past couple of years that we started to do that. We decided, like, our client's really angry about the repair issues. We don't encourage clients to withhold rent, but they come to us sometimes having already withheld rent, and they put the money in, they say, I have all the money. So we either can have them put that in the court registry, or if they feel that they can put extra money toward the back rent and come to our office and put that extra money in escrow. We sometimes have situations where we've saved up quite a bit of money, and by the time the court case comes to a fore, there's a lot less risk that a judgment for a monetary amount will lead to eviction because we have this money sitting in escrow. So there's all sorts of planning that you could do with your client. And then you want to think about, if the landlord's getting a judgment more, or getting to not litigate, which is about a couple of thousand, I don't know. I mean, I try to casually find out that information from the other side, like how much do you get paid? You can't really ask them that much, but it's like a couple of $1,000s I've learned to litigate a jury trial. So being able to pray a jury trial is very powerful for us if you can settle the case before the landlord starts doing pretrial materials, because once they start pouring money into that, they'll tell you, if I start doing that, then it's less likely that we're going to settle. So keeping that in mind, you want to make sure that you try to settle after discovery, but maybe before the landlord's starting to invest a lot of time and money into the case. In terms of pay on time agreements, particularly with the clients who we serve, who often with more time may have memory issues, or they could be in the hospital and not be able to pay their rent on time. Pay on time agreements are ones you should avoid. The exception is if the issue in the case is late payment of rent, because in that case, that is the issue. But you want to have a couple of opportunities to pay late without a penalty. So you'd want to weave that into the agreement. And again, that's something to run by your mentor. I always make sure that before mediation, I've drafted and my supervisors have drafted the settlement agreement so that you have it, your laptop there, and you're ready to go and don't have to spend all the time writing everything up. You could just spend time tweaking the agreement. So pay on time agreements are a problem. Also agreements that, and this is just not something you should never put in a settlement agreement, agreements that say the tenant will comply with the lease, and then it sort of seems a bit in perpetuity. Timeframes are important, but not having that clause where all the provisions of the lease are included. I say to the landlord, you're confined by what the complaint was for, what the notice to quit was for, because the tenant hasn't even considered all these other behaviors you're now trying to include in the settlement agreement. And I think that's a reasonable ask, that you only settle what has been sued for. That said, there are times where, of course, we've talked about creative settlements and getting your client what they want and getting the landlord what they want. Sometimes the carpet and all these other issues Beth was mentioning that are not in the property maintenance code, although we're making efforts to include wear and tear items, we're not quite there yet. That could be helpful to be a little flexible, but not give the landlord the kitchen sink. So I think we've talked about this a lot. There are some slides that, Beth had to cover a lot more slides than I do, and there are some slides that I think the material has already been covered. So in terms of consent judgment recipes, just to underscore what I said before, they are to be avoided at all costs if you can. There are circumstances where, and it's worth talking with your mentor, where that may be possible that's the only resolution and that going to trial is too risky, but you should definitely have a panel of experts give you an opinion so that you feel more confident in pushing back on the other side. I like the phrase, we were talking about this before, it's our office policy not to enter consent judgment recipes. I would be malpracticing if I did. I'm not allowed to. It sounds kind of wussy to say that, but it is our policy. We don't enter them unless it's an extreme circumstance, because we know how horrible it is to find housing as it is, let alone when you have a judgment on your record. And with our clients, they have a long history when their credit history could be stained in various different points of their life, so we don't want to create any further issues. Tenants with subsidies. That's an issue near and dear to my heart. I've been really thinking about that quite a bit lately because I've been editing a manual that I am going to end up sharing with the project and vetting that. But the manual is about dealing with the Housing Choice Voucher Program. It's in a very, very detailed fashion. So in terms of tenants with vouchers, there are a whole host of other considerations. We go to the Housing Authority every Tuesday to just pretend we're staff members and get as much information as possible. There have been a lot of transitions at the Housing Authority, a lot of key staff members who have left. If you want to learn more about DC Housing Authority, just Google Morgan Baskin and City Paper and DCHA, and there are a bunch of really cool articles about that, and you'll see a lot of quotes from legal services, people who you've met already. But the idea is when someone has a voucher, that's gold, and you can lose your voucher by getting evicted. I had a recent case where somebody had a drug haven eviction action against her, and it truly was happening. In fact, there was another raid while we were waiting. It's another case I got late in the game. Sometimes I feel really adventurous, and I think, got to keep myself fresh. Let's take this case, even though it's set for trial in like 3 weeks. And in that case, she had a voucher. If she got evicted for a drug haven, she'd be not only violating the voucher, her voucher obligations or tenant responsibilities for getting evicted, but also for drug-related activity. So we're very careful about involvement with the housing authority. We're not obligated to tell them, by the way, there's this pending eviction action. And what we did was I counseled her heavily. And in that instance, a move where she had family she could stay with was the right move, because there was a high likelihood she was going to get a judgment against her for a drug haven. So that's an example. I want to make sure you think about those special considerations for voucher holders. Think about timelines of how long it takes to find housing. Some clients, it's miraculous. They on their own will find housing through sort of word on the street. But our social workers who have been embedded, both of them have more than 20 years of experience in DC. They have a lot of trouble finding people housing. It takes a long time. So don't have a move out for a voucher holder. That's a resolution until you know they've identified a place. And even after they identify the place, make sure that that the lease up goes through. The lease up process, and we'll have a lot of detail in that manual. Again, I'll share that. The lease up process is excruciating in the sense that the landlord, you're depending on this landlord to do the whole process, and you don't have access to the portal that the landlord is submitting the information on. So you're trusting. You have to micromanage that landlord to make sure everything ends up getting resolved. There are people who help find people housing, and for the Aging and Disability Resource Center, there's one staff member, Plathon Watson, who helps people who, it's not just restricted to seniors, but helps them find housing. There is a robust social service network, and they can help people find housing. I know Bread for the City does that a bit as well. So just keep that in mind, that it does take some time. Moving process. I mentioned this already. This is the very in-depth, you identify a unit, you have to get the transfer voucher, but you don't want to get it too early because that's good for 6 months. And you have a lease-up package. Not every landlord, especially the smaller landlords, are that good at submitting the paperwork and making sure that's all clear and done correctly. If there are deficiencies, DCHA is supposed to let you know. We're there every Tuesday, and so we hound them about those deficiencies, but you do have to keep on them, and just even if you have to go down there in person and bug them, there are key people who we can give you information as to who they are. Keith Moon is one of them that we work with.
Say lease-up package, what's the nature of what you're talking about?
And we have a sample back at the office. In fact, that's going to be part of the manual, is to attach all that. But the lease-up packet is a thick packet where the landlord shares information about the property and the landlord, and because they're going to be getting payments from the housing authority, so they need to submit key information. Tenant will submit tenant information is on there. There are a variety of different forms that need to be. Right, exactly. And then the lease will be part of that. Once the lease is signed, and the housing authority gets a copy of that lease as well. So that's all part of the packet. And then DC Housing Authority still has to inspect the unit. And if there are problems with the unit, then the housing authority will issue a notice, and then hopefully the repairs will happen pretty quickly. The repair issues, as I mentioned, have to be corrected in order for the housing authority to pay on that, because they can't pay if there are housing quality standards violations. Yes?
So I just go back to before. So were you saying that you need to stay on DCHA?
Yes.
So it's appropriate to...
Yes. Not a problem to bother them, and you can get guidance from your mentor and from other people in the community as to who to contact. Katrina Jones, Keith Moon, Keith Moon's been there a long time. He's my KEMOONE at dchousing.org. So then the lease-up paperwork gets signed. So there's an order to it. So there's the paperwork, they fill it out, but then everything has to get signed after the unit's approved, and move-ins usually only happen the first of the month. However, if your client has a disability, or then there's a reasonable accommodation basis to change that time frame, we have been able to get the time frame changed, and someone can move mid-month, for instance. So the risk of loss of subsidy, I've mentioned that before in terms of vouchers. In terms of public housing and site-based Section 8 tenants, their subsidy runs with the unit they're living in. If they move, that's it. They lose their subsidy. So for public housing, site-based Section 8, you can know which one it is by looking at the preservation catalog. We're familiar as a community with which properties are public housing versus site-based, but you'll be able to get that information and make sure you guard that property for dear life, because if the tenant moves, they're going to be in the open market and the rents are high and less affordable. That's why you're so important. This representation is so key to making sure people can stay housed and keep affordable apartments, which are their last bastion. I mean, these subsidized units are the tenant's last ability to stay housed. So you want to make sure you counsel your client. Client may say, I want to move, but they're a public housing tenant. And you want to make sure they understand what they're thinking about. If their client has any mental health concerns and is not seeing a counselor and would be willing to get a referral, it would be really helpful to make sure your client's decision is sound and that they understand what they're going to be up against if they move. But let's talk about post-judgment. So if the landlord claims a violation, and I'll talk about this quickly because Beth had mentioned this before and we're sort of crunched for time at this point. But if the landlord claims a violation, the settlement provision is typically that the landlord files a motion for judgment. And now with e-filing, you may get complaints on like Maddie was mentioning, complaints from the landlord about having to file something, that you should be used to that process. So when the landlord-tenant rules will require 10 days in your settlement agreement, you can say more time because you need time to, who knows, you're the primary case handler and maybe you happen to be on vacation initially. I mean, there are all sorts of things that could happen. So you want to buffer, a little bit of buffer time to make sure everything's handled. And then the motions are set for an evidentiary hearing in landlord-tenant court in the upstairs courtroom. Who you get in that courtroom is really critical. Stay in touch with your mentor. There are others of us who will be in landlord-tenant court that day, and you can ask, is this a good judge to have? And if it's not, then try to see if you can get a delay in any way possible. Be prepared with witnesses and exhibits you may have to go forward. So it's just something to think about. Staying in touch with your client is important. Now that's another reason why the settlement agreements should be no more than the 6 months, because they're enforceable and you would want to monitor those cases for the 6 months after. So you are counsel of record still. That's really important. Having been at legal counsel for a long time, I've had situations where I've signed a really generous 5-year agreement and someone will come in and say, example of a bad day, come back from vacation and you're looking at, okay, I have to look back at this client, who it was and what happened, and you call them, but that's why you want to do the shorter period for the agreement. And you can make sure those judgments are served on your client as well, just in case you have other issues arise and you're not there. It's very important to get them, and it shouldn't be an unreasonable request that your client get that as well. And as I mentioned, your appearance remains in the case. Almost. Did I skip a? So if a tenant claims a violation, the tenant files a motion to enforce the settlement agreement. The judge issued, for instance, the repairs weren't made. The judge issues an order that the repairs be made by X date, 10 days from now. And if the landlord does not make the repairs, then the tenant can file a motion to show cause. And usually I set a status hearing by which the repairs would be made. And then that's how you get sanctions that Beth was talking about, reductions of the 12.5% rent that Beth was mentioning earlier. So the tenant should have in the settlement agreement the opportunity to file a motion to enforce the settlement agreement. And think about whether you can resolve this separately. Going to court takes a lot of time, as you may know. So usually the attorney just needs to talk with their client and let them know, look, if you don't make these repairs, then you're going to end up getting dinged. You're going to end up having to pay money. And lastly, if the tenant claims a violation, this is just a step-by-step, as I've mentioned before already, to file the motion to enforce. And then once the court order is violated, a motion to show cause and to ask for sanctions. And you should come to court just as prepared as you would be for trial, with the photographs and explanations of preparing your client to make explanations as to what the conditions were in the apartment and what hasn't been repaired. And thinking about contempt, I think contempt serves not just, so if a contempt is order is issued against the landlord, it deters the landlord from doing this again to your client. But I have found that people who've dealt with me 8 years ago when I sued them for affirmatively for repair issues, don't really want to deal with us very much. When this comes up again, you write a demand letter and you can solve the case. So it is a deterrent effect for the whole client community. So you're doing great work, not solely for your client, but for the client community generally. Knowing you're out there and the other side has seen you involved in cases, you're our ammo too, because they know that they may even like dealing with us a little more than having to deal with a large law firm with a lot of resources. And that's it. That's my inspiration to you, to thank you for doing this work.